from Senator Titus.
Thank you, Madam Chair. I'd just like to introduce my pages. If you guys would stand up. I have Regan from Topeka and Eric from Paxico with me today.
Well, welcome to the Senate Judiciary Committee. Hope you have a great day. And I also wanted to introduce a constituent who is shadowing me for the day, my friend Sally. So if you want to stand and welcome to the Senate Judiciary Committee and enjoy your day at the Capitol today. And with that committee, then, we will open the hearing on House Bill 2378, establishing the Removal of Squatters Act, providing a procedure to remove a squatter from a dwelling unit, requiring owners or agents of dwelling units to provide an affidavit to the county sheriff, requiring notice to vacate by the sheriff, establishing the crime of providing a false affidavit, and establishing a civil cause of action for wrongful removal of a person from a dwelling unit, allowing attorney fees and punitive damages. And with that, an explainer, a bill brief from the reviser.
Thank you, Madam Chair. House Bill 2378 would enact a few new sections of law. Section 1 provides essentially a policy statement, kind of like an intent of what the legislature would be doing with this new act. And Section 2 kind of gets into the meat of that, so we'll start there. It provides that the owner or agent of a dwelling unit may request the removal of an unauthorized person from the dwelling unit by submitting a notarized affidavit to a law enforcement agency in the county where that dwelling is located. That affidavit would be required to contain statements that the affiant is either the owner or an authorized agent with respect to the dwelling unit. A person has entered into and is remaining unlawfully in the dwelling. The person was not authorized to enter the dwelling. The person is not a tenant or a holdover tenant. The affiant has required the unauthorized person, or has requested the unauthorized person to vacate the dwelling, and the person has not done so. And finally, the unauthorized person is not an immediate family member of the property owner. An affiant who knowingly provided a false affidavit to law enforcement could be charged with a Class A non-person misdemeanor. Section 3 provides that on receipt of an affidavit, the applicable law enforcement agency is required to verify that the affiant is indeed the owner of the dwelling and appears to be entitled to relief based on the affidavit. After that verification, and at least 24 hours from receipt of the affidavit, a law enforcement officer shall serve notice on that unauthorized person to vacate immediately. Service may be hand-delivered or by posting notice on the front door or the entrance of the dwelling unit. A law enforcement agency shall attempt to verify the identities of all the persons who are occupying the dwelling and then note those identities in the return of service. The law enforcement officer would be able to charge a fee of up to $50 for providing that service of the affidavit. Section 4 requires the affiant owner of a dwelling unit to provide notice at the dwelling, notifying the unauthorized person that such person has no right to occupy the dwelling unit and they have to vacate immediately. The notice shall include the address of the law enforcement agency where the affidavit was delivered, and a copy of that notice has to be attached to the affidavit. Section 5 provides that no law enforcement agency or deputies or employees of that agency or any political subdivision will be liable for actions or omissions made in good faith under the Act. A law enforcement officer would also not be liable to any unauthorized person for loss or destruction or damage to property. Section 6 authorizes a person to bring a civil action for wrongful removal under the Act against the owner or agent of the dwelling unit. A person harmed would be able to have their possession of the dwelling unit restored and also may recover any actual costs and damages as well as punitive damages in an amount up to triple the fair market rent of the dwelling plus any costs and attorney fees. And then finally, Section 7 provides definitions for terms that are used throughout the Act, and it also provides that occupancy by a squatter is excluded from the Residential Landlord and Tenant Act, and removal of a squatter shall not require the use of an eviction action under this section. And I can take any questions.
Thank you. Committee, any questions? Senator Klemp.
Thank you, Madam Chair. One of the comments you made was that if it's a relative, it's not a part of this. Mm-hmm. Is that third cousins or just anybody that may claim relative status?
Sure. Thank you, Madam Chair. So the term that's used is immediate family member, and that term is defined on page 3 as a spouse, child, grandchild of any degree, parent, mother-in-law, father-in-law, grandparent of any degree, brother, brother-in-law, sister, sister-in-law, half-brother, half-sister, uncle, aunt, nephew, or niece, whether biological, stepped, or adoptive.
It's probably for a comfrey, Madam Chair, but I'd be interested to understand why that's included in that. Thank you.
Yeah.
Thank you. Committee, other questions for the reviser? Not seeing any, then thank you very much. Appreciate it. First, we will hear from, just a moment. We have quite a few conferees signed up to testify today, so we're going to need to limit testimony to 4 minutes per conferee. And when you have 1 minute remaining, please keep an eye on the front of the room while you're testifying as well, and I will hold up the folder for 1 minute remaining for you to wrap up your comments. So with that, then, we will invite our first proponent conferee, Representative Will Carpenter, Kansas House of Representatives from the 75th District. Please introduce yourself and welcome to committee.
Very good. Will Carpenter, representative from the 75th House District. Good morning, Madam Chair, committee members. I stand in strong support of this bill. I introduced it last year, and the realtors quickly came to me, and Ben's, I'm not a realtor. There were some issues with it. I said, okay, if I'm going to pull this bill back, then we're going to work throughout the summer and get this bill ready to go. This session, here it is. It passed the House 114-9. It's been through our Judiciary Committee. It's a mixture of the Alabama and Florida. And since then, 4 states had passed these bills, so we were able to use some of the language that they had already passed throughout their legislature. And this bill is a mixture of the Florida and Alabama law. And so I urge your support. I'll stand for questions at the appropriate time.
Thank you, Representative. I understand the House will be on the floor at 11, so if you'd like to entertain questions at this time, that would help you get to the House floor on time. Would that be all right?
Sure.
Great. Well, any questions for the representative? Not seeing any, then you'll get to the House floor pretty early. So
Good. Thank you. Thank you, committee.
appreciate your testimony. Thank you. Next, we will hear from proponent conferee Mark Toom, Vice President of Governmental Affairs, Kansas Association of Realtors. Please introduce yourself and welcome to committee.
Thank you. Thank you, Madam Chair, members of the Senate Judiciary Committee. My name is Mark Toom. I'm the Vice President of Governmental Affairs with the Kansas Association of Realtors. We stand in support of House Bill 2378. And really the focus here is really removing individuals that have really no connection to a property. The question that was brought up earlier about family situations, I think that gets into a different realm of removal from a property if it's a long-standing family property. And so we actually expanded the definition of family and what that family member means on the House side. Other disputes, making sure that there's not any landlord-tenant relationship, that if this is not a substitute for eviction, this is for somebody that clearly has no legal right to being at that property. So this is not a holdover tenant. This is not somebody that can even be confused to have some sort of a landlord-tenant where it should go through the eviction process. What this is designed is meant to be an expedited process so that law enforcement can quickly remove these and return these to productive use. So we're hopefully being able to return it to productive use in days rather than court proceedings that sometimes takes weeks and maybe even months. So with that, I'll stand for questions at the appropriate time. Thank you very much for considering this at such a late date.
Thank you, appreciate it. And we'll hold questions from committee till the end of proponent testimony. Thanks a bunch. Next, we will hear from Sheriff Jeff Easter, Kansas Sheriff's Association Legislative Chair. He's appearing on WebEx this morning. Please introduce yourself and welcome to committee.
Well, good morning, Chairwoman Warren and committee members. I'm Jeff Easter. I represent the Kansas Sheriff's Association.
Sheriff, you're going to have to unmute. We can't hear you.
Can you hear me now?
Nope, still can't hear you. Okay, well then we'll make your testimony then written testimony. So thank you, Sheriff, appreciate it. And there's no complication on our end, is that correct, on the technology? So, okay, we're all clear on
Can you
this
hear me
end,
now?
so, no, still can't hear you.
Okay.
All right, we got our volume turned up here and all, so. Okay, did you want to try one more time, Sheriff?
Yes, can you hear me now?
Yes, okay, there we go. All right, go ahead. Please introduce
Okay.
yourself. Please introduce yourself and welcome.
Good morning, Chairwoman Warren and committee members. I'm Jeff Easter. I represent the Kansas Sheriff's Association. We testified on this bill in the House and asked for some suggestions for amendments, one of which that the affidavit has to be notarized. This amended bill has that in there. The next was a definition of immediate family, which is on page 3. A third suggestion we had was to remove criminal damage to property, or to look at criminal damage to property. We agree with the decision to just strike the subsection as unnecessary. We also asked for it not just be the county sheriff, that it would be any law enforcement agency, which allows for any law enforcement agency officer to serve the notarized affidavit to a squatter within their jurisdiction. That is now reflected. The main reason for that is normally what occurs in evictions. That's a judicial review through the district courts, which then goes straight to the sheriff's offices to serve. There is no judicial review on this. So this should be something that any law enforcement officer can serve within their jurisdiction. We asked for the phrase on page 2, no law enforcement agency or such agency deputies or employees. The amended bill reflects this request, but we believe deputies or could be stricken, leaving law enforcement agency or such agencies employees. We are also requesting an amendment on page 1, line 22, the words in the county to with primary jurisdiction. The only other question we have, being that there is no judicial review, this isn't a eviction process. If the squatter refuses to leave, what's the intent of this bill for law enforcement action on this? Is this to arrest him for trespass or some other criminal charge once the landowner has gone through this process? And with that, I will stand for any questions.
Thank you, and I'm glad we got connected there, so
You too.
thanks for your patience. Next, we will hear from Chief Darrell Atterbury, Legislative Committee Chair, Kansas Association of Chiefs of Police. Please introduce yourself and welcome to committee. I have the chief as appearing here in the committee meeting room, but I don't see him, and I don't think he's on WebEx. So we'll give him an opportunity before we close the proponents. Mr. Klump, did you want to come? Okay, great. So we heard from the Kansas Association of Chiefs of Police representative who said that the chief is testifying in another committee, and this was intended for written testimony proponent, so we will take that as written testimony then. Thank you. Next, we will hear from Kylene Lindgren, Legal Policy Manager. Please introduce yourself and welcome to committee.
Thank you, Madam Chair, members of the committee. My name is Colleen Lindgren, and I'm a legal policy manager for Pacific Legal Foundation. We're a nonprofit public interest law firm that represents clients free of charge when their constitutional rights are violated, and we've been doing so for over 50 years. We've litigated 2,400 cases and won 18 of these at the U.S. Supreme Court, over half of which relate to the issue that we're here to talk about today, which is property rights. We've also helped enact more than 36 laws in legislatures around the country. And specific to the issue of squatters, I'm aware of at least a dozen other states considering or who have enacted similar reforms recently. The most recent being Wyoming and Arkansas, where we were also active on the ground on this issue. HB 2378 addresses a growing issue that we're seeing in both litigation and legislation, problem of squatters unlawfully occupying private property and legal challenges property owners face in reclaiming their homes. So currently many states lack an effective mechanism to remove squatters, forcing property owners into lengthy and costly eviction proceedings. even when the occupants have no legitimate claim on the property. So this places an undue burden on homeowners and enables bad actors to exploit legal loopholes. And so this bill just makes a few crucial reforms we think are important. I'm going to highlight them quickly for the sake of time. But it ensures that law enforcement has the authority to remove unlawful occupants swiftly. So empowering law enforcement to take immediate action, establishing legal distinctions between legitimate tenants and those who may falsely claim to delay removal. It protects property owners from financial and legal hardships by streamlining the process for reclaiming property. And last but certainly not least, and maybe most importantly, this bill penalizes false reporting. And we want to make sure that the guidelines are clear for everyone involved in the process. And we believe that the right to exclude trespassers is a fundamental component of property rights under the Fifth Amendment. When squatters are allowed to remain in a home simply because of procedural hurdles like having to go to court, it constitutes an unconstitutional taking of property. And with HB 2378, the state is helping to solve that issue, aligning with constitutional principles in restoring property owners' rights and ensuring the law does not inadvertently protect unlawful occupants in the expense of rightful owners. As I mentioned earlier, over a dozen states are considering reforms, and several have already done this in the past year, including Florida, Oklahoma, Tennessee, Missouri, and Missouri. And Kansas has the opportunity to do the same and protect everyone involved in this often difficult process by passing HB 2378. So for these reasons, we ask for a favorable vote on HB 2378, and I'm happy to take any questions that the committee may have.
Thank you. Appreciate it. Are there any other persons wishing to testify as proponent on the bill? Not seeing any, then committee, I want to direct at your desk. You also have proponent written testimony from Elizabeth Patton, Kansas State Director, Americans for Prosperity, Kansas. And with that, then we'll open it up for any questions. Senator Bowser.
Thank you, Madam Chair, and maybe I'll direct my question at Mr. Toom. And it might be the same sort of question that Sheriff Easter had. Let's assume that the proper eviction notice has been served. What then are acceptable police actions? Can they arrest these people for trespassing?
Yep. Those crimes will still be.
Please introduce yourself again.
Yes.
Thank you.
Mark Toom again with the Kansas Association of Realtors. This is going to be one, an expedited process, but the options of trespassing and in many jurisdictions, that's simply when you find somebody on property that doesn't belong there, that's what it's going to be. That option still exists as a criminal charge, and there's a long list of charges that could probably be charged for somebody that's not in a space when they're not supposed to be, when they're in a space when they're not supposed to be.
Yes, Senator Corson, then Senator Reichman.
Thank you, Madam Chair. I shared Senator Bowser's question and concern. I don't want to put law enforcement in a position where it's unclear what we're expecting out of them and what we view as appropriate conduct. I'm worried that this bill doesn't really provide that guidance spelled out, because I do think there could be times where law enforcement arrives at this, call it a residence, and the person who's allegedly squatting says, no, I actually have a lease, they're lying, there's some sort of a dispute about that. And then what is it at that point? If the person says, no, I have no right to be here, I'm squatting, that's one thing. But I think in many instances there will be some sort of at least a colorable initial defense or pushback, and then what is law enforcement supposed to do? So that's kind of my first question, to amplify what Senator Bowser said. And then my second would be, at the outset, I'm wondering if maybe it makes sense. I know we want this process to be speedy, but does it make sense to go to a judge? And this may be more of a question for Sheriff Easter probably, but does it make sense to go to a judge like we do with an arrest warrant or search warrant and get a judge to look at the affidavit and sign off and say, okay, I think it makes sense. I think that they've answered all the appropriate questions and listed they met their obligation. I think that they don't have a legal right to be on the premises. I'm worried about, shouldn't a judge be involved somewhere in this process before we're just showing up at a place? Shouldn't a judge sort of give an okay and say, I think there's at least a reasonable belief that this is correct? And again, that second question may be more of a Sheriff Easter question, but Thank you.
No, I appreciate the question. I think that what we're trying to create a simple tool here. I think that having that judicial component to it will, I think that if it becomes more complicated, if somebody is saying that they have a lease that they may not be able to produce, or that they have some sort of, that they're going to make a case that they somehow have a legal reason to be in that space, then they're getting in front of a judge at some point, and there are also probably going to be additional charges filed, trespassing being one of them. So this is meant to be a tool. It doesn't have to be the only tool. In certain situations, it may be more heavy-handed, more of a law enforcement and charges. They're going in and having that. This is a tool that will be that's really meant to be simple. So I think that if you have that judicial component to it, it's going to make a simple tool more complex, and it probably won't be used. I think there are protections in place here. If that property owner is lying on that affidavit, there's a recourse for that person, and so there'll be consequences.
Thank you. Senator Reichman.
Thank you, Madam Chair, and I guess I can address this to you too, Mr. Toom. I thank you for your testimony. My question is really on the line, the other two, I didn't know what questions I was going to ask. Some people are, some of the other testimony, they're always concerned about due process. And when someone doesn't supposed to be there, it's illegal, or they're broke in and they're living without a lease or anything like that, I have, I throw the book at them as far as I'm concerned. I understand why they're bringing this. I think some of the question is, if there is a question, are they overstaying their welcome and they have a leash or whatever? So you kind of answer that. No, that's the kind of where I'm not quite sure if there's a question, if there's a debate, if they should be there or not. Thank you.
This is really meant for the situation where they really have no legal right to be in that space. So, and that landlord is, that the property owner is going to certify to that effect. So if that's not correct, then there's consequences for them. But this is, like I said, it's not going to deal with the messy family situations. It's not going to mess with landlord-tenant that's holdover tenancies and things like that. Those are out of bounds from this simple tool. So that's why I think not having that additional judicial component is available in this kind of a situation, because it is meant to be an expedited and very narrowly focused.
Thank you. I'd like to follow. Do we have many cases in Kansas where, well, let's say we're having squatting going on in,
do we have a problem?
do we have a big problem? Do we have any numbers? Do we have any idea where this is happening? Thank you.
I don't believe there's any record keeping that would be accurate in that. I know that certainly nationally we're hearing a lot of cases. I hear from legislators when there are a lot of national features on cable news, and there are horror stories where people have been allowed to live in properties for far too long. We don't have that kind of a problem in Kansas, but we don't want to also invite that kind of a problem in Kansas either.
Thank you. I have a few follow-up questions as well. And I support the intent and purpose of the bill about the fundamental rights of owning property, including the right to exclude others from entering or remaining unlawfully on the property. When we look at the definition of squatter, so the definition of squatter in the bill means a person occupying a dwelling who is not entitled to occupy the dwelling under a lease or rental agreement. Well, you have other rights, don't you, to occupy a dwelling that isn't a lease or rental agreement. For instance, if you own the property, or if you're the child and your parents own the property and you're a minor. So I'm thinking maybe we need to look at that definition a little bit. What are your thoughts on that?
I believe that definition was also expanded, I think, in a committee amendment in the House, if I'm not mistaken. I'm agreeable to other definitions to tighten things up, because I like you, I think that this is an important issue underlying, but if there are suggestions for improvements, we're welcome to those for sure.
And for a law enforcement agency who appears to hand deliver the notice, the bill also requires on page 2 that the law enforcement agency shall also attempt to verify the identities of all persons occupying the dwelling and note the identities on the return. Does that involve the ability to enter the dwelling without a warrant?
You would probably have to have the permission of the property owner, which I assume that you would in this situation, because the property owner is inviting law enforcement on their property.
Because they have filed the affidavit. And so what if the property owner who has filed the affidavit isn't present when the notice is delivered?
I don't know that they would have to be present, would they?
Well, to give permission. So are you saying by...
I think they could give permission beforehand.
Okay, so filling out the affidavit is permission to enter and do a search.
I think that it would be the requirement of what the sheriff would want, but yes, I think that would be my understanding. You'd give them permission.
And then regarding punitive damages, is your association in favor of punitive damages?
To the person who files an improper affidavit?
Right.
I think right now it's a lower level misdemeanor. So if there's penalties, yes. If you're lying on something to a government agency, yes, absolutely.
So if you're a homeowner and you don't usually rent out any part of your dwelling, the damages, the punitive damages are calculated as triple the fair market rent of the dwelling. So how is one going to prove what the fair market rent of the dwelling is?
That's a good question. I'm not 100% sure how that would be. I think a judge would have to probably calculate that. That would be something that's going to be in front of a judge, so they would probably need to make that determination.
So the homeowner of the dwelling would have to provide some testimony in the punitive damages case against them about what the fair market rent is of the dwelling?
I think they would probably have to argue that point.
And why did the committee, or excuse me, the association who helped put this together regarding punitive damages, why triple rather than just state punitive damages is the fair market rent of the dwelling? Why the triple? Because punitive damages aren't necessarily a usual item in a private cause of action. So I'm kind of curious about the details of this.
That was an amendment. That was not something that. Where is that actually in the bill? I'm trying to find that.
Sure, that's on page 3, lines 1 and 2.
I'd have to do some investigation on that. I'm not.
Sure, and we can follow up. Thank
Sure,
you.
I will do that.
Any other questions for the proponents? Not seeing any, then thank you very much for your testimony. We will hear from neutral proponent Rebecca Gaston, a Kansas attorney. Please introduce yourself and welcome to committee.
Good morning, Chair Warren and members of the committee. My name is Rebecca Gaston. I'm an attorney in Kansas. I've been licensed since 2005, and I'm appearing here in my individual capacity as someone who recently handled dozens of eviction cases. I was working for a nonprofit for between 2022 and 2024. So it's pretty recently that I've been doing that, but I'm not doing it at this time. I thought it would be helpful for the committee to have some perspective from what happens in court with similar cases. I'm here as a neutral conferee just because this eviction process is pretty complicated, and as an attorney for over 15 years, I knew nothing about it. I didn't realize how quickly evictions went. I didn't realize that 4% of tenants have attorneys and 83% of landlords do. So just wanted to share some concerns about the bill. It seems like it needs probably some more amendments at this point. The number one concern is just the lack of court oversight. This bill really doesn't provide due process to tenants, occupants, trespassers. So one example that I think sort of came up, but somebody who'd lived in an apartment or house for 20 years, had a written lease, the sheriff could show up on their door. They have this affidavit. It may not be true, but there's no mechanism for the sheriff to consider that person. They could have the written lease and the sheriff could see it. This looks legitimate, but there's no mechanism. They're required to remove this person. Another concern I have, just with the language of the bill, I think Chair Warren mentioned the definition of squatter. But when you look, so that's in section 7, but in section 2, when we talk about what the affidavit requires, it doesn't require that the person be a squatter. The language it uses is more about a trespasser. So it says that they have entered and are remaining unlawfully in the dwelling unit. And that's really consistent with what KSA 215808 it says for criminal trespass, entering or remaining upon any land, structure, etc., by a person who knows they're not authorized to be there. Another concern is that current statutes do seem to provide adequate remedies. When you've got a trespass, you notify the person that they're not allowed to be there, and they can be arrested for criminal trespass. If it's someone who's truly occupying that dwelling, eviction is the appropriate remedy. And in Kansas, evictions move really fast. Like, the landlord gives you a 3-day notice to vacate. They can file a petition after 72 hours. After the petition is served, the answer hearing has to happen within 3 to 14 days, and after that answer hearing, the trial has to happen within 14 days. And there's not like a good cause that the judge can give you a continuance for a trial if you're a tenant. So these move incredibly fast, usually done within about a month maximum, if the person shows up at all the hearings and things like that. Another concern is in section 6, there is that provision that allows a wrongfully removed person to seek damages, but they have to go to court. They have to find a lawyer. Well, first they have to know that they have that right. Currently there's no requirement that the sheriff provide information on that right. So they're removed, they're homeless, their life is in chaos. If they can find, they're not gonna have probably the capacity to find an attorney. Kansas already has a shortage of attorneys, as we've heard a lot this session. And in eviction cases, tenants rarely even have attorneys. So that's gonna be hard for them to take advantage of that provision. The last thing I wanna mention is some of the other testimony. So Michelle Ewert from Washburn Law Clinic will be emailing you all. She didn't have time to submit testimony in time, but I think her perspective as someone who's handled housing cases for a long time is really valuable. I also wanted to highlight what Sheriff Easter said about just the lack of clarity about how this will be implemented without judicial oversight. So thank you, and I'm happy to answer questions at the appropriate time.
Thank you. Is there anyone else wishing to testify as neutral on the bill? Not seeing any, then we'll go ahead and open it up for any questions. Sorry. Yes, Senator Corson.
Thank you, Madam Chair. So is it fair to summarize sort of your concerns by saying that one of the, I think, problems with the bill as it's currently written is that all of the remedies, all of the process is all post hoc, right? So if somebody knowingly provides a false affidavit, then they could later be charged with a Class A non-person misdemeanor. But that's after this process has largely already played itself out. And then same thing, Senator Warren, Chair Warren has already talked about Section 6. After somebody's already been wrongfully removed, then they can bring a legal matter. But all of that is post hoc. There's no judicial review contemporaneous before law enforcement just basically shows up and forcibly removes this person from their dwelling. Is that a kind of fair summary of what your big picture concerns are?
Rebecca Gaston, yes, that's absolutely a concern.
Thank you. I want to make sure that law enforcement doesn't have any ability to remove the person from the premises. Maybe that's a question for the revisor. Is it just serving a notice, or is it actually removing someone from the premises? Because I see it's only serving notice, and there's no process for actually removing them from the premises.
Madam Chair, thank you. Yes, the bill just speaks to serving that notice. Of course, law enforcement would have the ability to arrest the individual for a crime like trespass or something like that, so then they would be being removed. But the bill doesn't speak to any kind of specific method for removing them when they're serving this affidavit.
So there's no, like you just said, there's no new process created in the bill removing a squatter from the premises. Okay, thank you for helping clarify that. Any other questions for our neutral conferee? Senator Shane.
Thank you, Madam Chair. I guess I'm just going through my mind, like when I'm thinking about someone that's trespassing, prior to law enforcement removing somebody from a property on which they are trespassing, there is no judicial review or intervention permission process to remove someone from a property where the owner has said they're trespassing. Would that be correct?
Yes. Usually, I mean, it requires either that the person be notified, maybe there's a sign posted. Sometimes, like if somebody's trespassed from like the public library or something, they'll give them like a criminal trespass warning, like you're not allowed to come back. Then if they come back, they're arrested. But there's no judicial review prior to that arrest.
Yeah, I guess that's one of the things that I'm sorting through is that in the case of a tenant or somebody that's legally occupying a premise, that's why there is an eviction notice, right? There's some sort of contract that's been broken. In this case, there is no such contract. The assertion is that there is no contract that there is to enforce. So I guess I'm wondering how this is different than how law enforcement would have to handle criminal trespass. And so that's something I'm mulling through. Providing, a preliminary injunction from the judiciary, for instance, puts the legal cost and ramifications onto the rightful property owner who is asserting that there's trespass. And this is certainly a difficult one to navigate the rights for, but I think the law's intent is trying to create a distinction between a quote-unquote squatter and someone who at least one point in time was legally occupying a dwelling. Would you agree with that?
I think so. I think that seems to be the proponent's intent, to focus on squatters, but it also, just the language in Section 2 doesn't call back to that squatter definition. It talks really about what's trespassing. And I think one thing you mentioned about putting the obligation on the landowner to seek judicial review. I think if there was an ex parte like review similar to like warrants, like Senator Corson mentioned, that's going to be a relatively quick process, and they'd have to pay for attorney time, but it's not going to be as expensive as an eviction trial would be. So that might be something to consider. I don't know if you had another question that I didn't answer yet.
So it's true, though, that if you aren't in a landlord-tenant relationship by contract, you're not going to be able to avail yourself as the dwelling owner of the landlord-tenant law. And maybe that's a question for the reviser, but to Senator Shane's distinction that we're not talking about tenants who have a legal contractual relationship, and we can decide whether that's expired or whether it's still enforceable or not. But these are for folks who are on premises who don't have that landlord-tenant relationship. So, there's criminal trespass, and a landlord short of that would be doing what without this bill?
If it was somebody who was a squatter in that they're asserting that they have a right to live there, the landlord would probably do like kind of that process I mentioned in my testimony. So you have the 3-day notice to vacate, and then you're going through that eviction process.
But that's not, you're not a tenant, so you don't get the eviction process without being a tenant, if I'm right on that.
Yeah, so I was talking to some other eviction attorneys to try to talk through this, because there's not case law on squatters in Kansas. There's not a lot of, I never saw kind of a typical squatter case during my practice. I don't know how common they are, but I think probably the main concern is this bill is intended to cover squatters, but somebody who is a legitimate tenant could get wrapped up in it and kind of get wrongfully removed. To your question about what the Landlord-Tenant Act covers.
Well, I could see this being a problem in Kansas for certain property owners, and you probably haven't seen any cases because right now there's no statute regarding squatters. Yes, landlord tenants, but not for someone who's occupying a dwelling who's not legally entitled to be there. And I think for trespass, I'd have to do some further research, but I think that's a criminal remedy. So I'm just wondering if there's a civil remedy without this bill for those who have persons in their dwellings that is not a tenant and won't leave. So those are kind of some of the discussion questions we've been having. Senator Schmidt.
Thank you, Madam Chair. Hopefully, if I can constructively muddy the waters along your line of questioning, this is I can imagine a scenario, and I know it happens in my district so much so that it was a topic at a sermon this past Sunday in Central Topeka, where people feel that their landlords are not providing, not living up to their end of the lease, so they withhold payment either in part or in whole, and it gets them creates a very complicated legal situation. But that could be a situation where they're not paying, but they believe that their landlord is in violation of the lease. So, and I agree, this is all very complicated.
Well, thank you, Senator. In that case, you would fall under the Landlord-Tenant Act, and you would have the remedies available there because you're a tenant. But it just kind of raises the question: if you're not a tenant, what does a property owner do? So, and it's not necessarily a question you have to provide a solution for, but.
I do have a thought, if I may. I think they could get a civil protection order if, in some cases. I also wanted to highlight, so the Landlord-Tenant Act is Chapter 58, and then the eviction statutes are in Chapter 61, which is the civil procedure for limited actions. And so the Landlord-Tenant Act does speak to specifically to people who have leases, and it can be an oral lease, but the eviction statutes just speak to notice to vacate. So if you don't have a lease, there's no requirement to terminate the lease prior to filing an eviction. So I think the eviction statute should still apply even if there's not a lease.
The eviction statute would apply if there's not a lease. So
like 613803 maybe?
Yeah.
Because you actually have to terminate the lease prior to filing the eviction. You have to do that notice to terminate lease, either a 30-day notice for a lease violation or a 3-day notice for non-payment.
Right, so some additional research to look at and some additional considerations. Well, any more questions for the neutral conferee? Not seeing any, and then thank you for your testimony. Next, we will hear from opponent conferee Nathan Madden from Impact Strategist, Policy Health Forward Foundation. Please introduce yourself and welcome to committee. Except I don't see, I'm sorry, it's written only. Apologize. And we also have opponent written testimony from Dustin Hare, Economic Security Policy Advisor, Kansas Action for Children. Is there anyone wishing to testify as an opponent conferee on the bill? Not seeing any, then we will close the hearing on House Bill 2378 and open the hearing on Senate Bill 116. Just a minute, however. Well, we'll have the bill brief from the reviser. It's requiring prosecutors to disclose their intent to introduce testimony from a jailhouse witness and to forward related information to the Kansas Bureau of Investigation. And with that, the bill brief from the reviser. I almost asked you to introduce yourself and welcome to committee, but
No stranger to this committee, Madam Chair. Senate Bill 116 would add a new section of law in the Criminal Procedure Code. It would require a prosecuting attorney to disclose their intent to introduce testimony of a jailhouse witness regarding statements made by a suspect or defendant while such suspect or witness or defendant were both incarcerated. The prosecuting attorney would be required to provide to defense counsel the criminal history of the jailhouse witness's cooperation agreement, and any benefit that may result, the contents of the statements allegedly given by the suspect or the defendant to the jailhouse witness, and the contents of any statement given by the jailhouse witness to law enforcement regarding those statements. Any information regarding the jailhouse witness recanting testimony or statements would also have to be provided, and also any information on any other criminal cases in which testimony of the jailhouse witness was introduced or intended to be introduced. The court may extend the time for the prosecutor to comply with the provisions of this section if the jailhouse witness was not known or the information could not be discovered or obtained in time. If the court finds that disclosing the information described above is likely to cause bodily harm to the witness, then the court can order that that evidence be viewed only by defense counsel and issue a protective order. Each prosecuting attorney's office would be required to maintain a central record containing information on any case in which testimony is introduced or is intended to be introduced and any benefit associated with that testimony. The prosecuting attorney's office shall forward that information to the KBI, and then the KBI would be required to maintain a statewide database that's only available to prosecutors and would otherwise be confidential. If a jailhouse witness receives any benefit in connection with offering or providing testimony, then the prosecuting attorney has to notify any victim connected to the criminal prosecution. Subsection D provides definitions for benefit and jailhouse witness, so you can read those there. I think that's it, and I'll stand for any questions.
Thank you. Committee, any questions? Thank you. Committee, we're going to change the order of our business here today just a bit. We do have a number of conferees on Senate Bill 116, but do want to make sure we have an opportunity to work some of the bills that we have heard that have, we've got till tomorrow to do that. So I wanted to, for your consideration, pull up Bill Senate Bill 288, and we heard that last week regarding registered sex offenders who have committed a crime against a minor, involving a minor, and are therefore on the registry, and restricting their access to school property and school activities. And with that, a brief summary from the reviser.
Thank you, Madam Chair. Senate Bill 288 would prohibit adult sex offenders who committed an offense against a person who's under 18 years of age from entering onto or remaining on school property, and also from attending any school activities. And I can take any questions.
Thank you. Any questions for the reviser? Not seeing any, then is there any discussion? Senator Titus.
Thank you, Madam Chair. I have an amendment if the reviser could pass it out.
She will, and we'll wait for that to be distributed, and then we can discuss it. Or you can explain it or have the reviser explain it.
So it's relatively straightforward in that if you go to page, let's see, and it's on page 3 or 7 of the bill here, but I wanted to modify the term an accredited non-public school. That's a vague term, and it's either too restrictive or a little vague in statute, because accredited school can mean different things in different parts of the statute. So I just rewrote the definition to be clear what we're trying to capture here. The idea is that we don't want this to apply to very small homeschool type operations. So I've just drawn some sort of clear lines, offers regular instruction at least 4 days a week, and it does not include those things, but I thought that the accredited term was a little vague for a bill like this, so I would have moved my amendment.
Thank you. Is there a second? And if there is, then we will have discussion. Senator Klemp with the second. Any discussion on the amendment? Not seeing any, and he has closed, but go ahead. You want to close on your amendment, Senator Titus?
I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye.
Aye.
Those opposed, no. The motion carries. And we're back on the bill. Committee, this is a bill that we're late in the session, and in order to be able to work on it in conference committee with the House, want to make sure that it goes straight to conference. So we're going to open House Bill 2164, and we're going to put it in a House bill so it can go right to conference. I think this is an important measure to protect kids from sexual predators being in school properties and at school activities. We heard testimony from parents involved in an incident last month at an elementary school, and we've heard support from the school superintendent for the bill from the KNEA and prosecutors that this is an important concept to, in my view, move straight to conference committee. So the intent is to open House Bill 2164, allowing 20-year-olds to apply for certification as law enforcement officers, and put the contents of Senate Bill 288 as amended into 2164 after we remove the content of House Bill 2164. And the reason we're looking at House Bill 2164 is there have been some concerns from law enforcement agencies across the state about the impact of what the bill would do. So it would allow time for law enforcement agencies and others to come to the table and talk about how can we find resolution to a potential problem that we're seeing across the state in having folks enroll in law enforcement officer programs without impacting already what's in statute. So it's not something in what I'm hearing from law enforcement that's a bill that's ready to otherwise move forward this session. So that's why we're looking at House Bill 2164. So with that then, I need to make a motion to we're going to open House Bill 2164 to work it, and the motion is to remove the contents of House Bill 2164 and insert the contents of Senate Bill 288 as amended into House Bill 2164. Are there any questions on, is there a second for that motion? Senator Rose. Is there any discussion on the motion? Not seeing any, then I'll close, and you all have heard the motion, so all those in favor signify by saying aye. Those opposed, no. The motion carries, and we are then on, I guess that would be Senate substitute for House Bill 2164. Is there a motion regarding the Senate substitute for House Bill 2164? Senator Rose.
I move that we pass the Senate substitute for House Bill 2164 favorably.
Thank you. Is there a second? Senator Bowser. It's a mouthful and complicated process, but thank you. Any discussion? Not seeing any. Did you want to close, Senator Rose?
Yes, thank you, Madam Chair. I close.
Thank you. You all have heard the motion. All those in favor signify by saying aye. All those opposed, no. The motion carries. Thank you. And the next one I wanted to take a look at is House Bill 2192 regarding limiting work release for domestic battery. And that's a bill that we heard last week as well. And with that, a brief summary from the reviser.
Thank you, Madam Chair. House Bill 2192 would require that batterer's intervention program on a first-time domestic battery conviction, and then it would increase the required minimum incarceration lengths for a second time and prohibit work release for a second and third conviction.
Thank you. Any questions for the reviser? Not seeing any discussion? Committee, I did have an amendment to change the enactment date from the register to, from the statute book to the publication in the Kansas Register. Is there a second? Second, Senator Reichman. Thank you. Wasn't looking that direction. Thank you. You all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We're back on the bill. Any further discussion? Then is there a motion regarding the bill as amended? Senator Shane.
Thank you, Madam Chair. I move that the committee pass House Bill number 2192 as amended favorably.
Thank you. Is there a second? Senator Rose. Any discussion? Not seeing any. Did you want to close on your motion?
I close.
Thank you. All those in favor signify by saying aye. Aye. Those opposed, no. The motion carries. With that then, committee, thank you for your work on working those bills, and did want to get back to the hearing on Senate Bill 116. We do have a number of conferees and want to make sure we're not getting into repetitive testimony. It is a concept that committee has heard before. We did pass out a similar bill last session out of Senate Judiciary Committee, and it was below the line. And with that then, want to make sure we have plenty of time for questions. We'll limit testimony to 2 minutes per conferee. And with that then, we'll invite proponent conferee Tricia Rojo Bushnell, Midwest Innocence Project. Please introduce yourself and welcome to committee.
Good morning. Thank you, Madam Chair. My name is Tricia Rojo Bushnell. I'm the Executive Director of the Midwest Innocence Project, and I was one of the attorneys that represented Pete Coons. 4 years ago, on November 5th, 2020, Pete Coons was exonerated and released from prison after serving 16 years for a crime he didn't commit in Wyandotte County. His wrongful conviction rested in large part on the use of a jailhouse witness or a jailhouse informant. Tragically, his reunion with his family was cut short when he died 108 days after he was released from prison from cancer that riddled his body and went untreated and undiagnosed while he was incarcerated. But after his death, the legislature introduced this bill, the Pete Coons Memorial Act, which would reform the use of those informants, like the informant that was used to convict Pete, and help ensure that no other innocent Kansan or family would face the same fate. And for 4 years, his family has continued to appear and relive the worst moments of their life, the loss of their father and their loved one, that could have been prevented if this bill had been passed. And they would have been here today as well and asked that you consider their previous testimony, but for the fact that I could not ask them to relive that. Because tragically, 4 years later, with all of that information, and with the support of every body that this bill has come before, every time this bill was up for a vote, it has passed, and yet the legislation still has not gone through. And I think we owe Kansans more than that. Because in and of itself, the protections that this bill creates should not be controversial. It does not eliminate the ability of the state to use jailhouse informants, but rather it provides safeguards in how they are used, and it provides the ability of them to comply with those duties. First, by creating a database so that they know the information that they need to provide over, by clarifying that information that folks need to provide over, and by allowing notification for victims' advocates so that they will become aware of that. Notably, 14 states have recognized the importance of this bill and passed this legislation. And in fact, Missouri did so just last week. And they will sign that bill, the governor will sign that bill into law on Wednesday. And the Missouri legislature, led on this issue by Republican Nick Schreur, passed this provision not because it had to, but because it was the right thing to do. And it did so without any opposition to this bill whatsoever, not by the prosecutors, not by the attorney general, and not by law enforcement. It is often said that the right thing to do can be the hard thing to do, but I don't believe that. I believe the right thing is only hard when we are distracted from the issue in front of us. And this bill is not only right, it is popular. It has passed every body it has been put in front with overwhelming support. It is bipartisan support, and it has the support of victims' advocates. And originally had no opposition until that tragically changed as 2 years passed. We ask that Kansas join the other states who have recognized the importance of ensuring only reliable testimony is used by jailhouse informants. Thank you.
Thank you. Appreciate your testimony. Next, we will hear from proponent conferee Mark Zimmerman, Executive Director, Miracle of Innocence. please introduce yourself and welcome to committee.
Good morning. My name is Mark Zimmerman. I'm the Executive Director at Miracle of Innocence. Thank you for taking a few minutes to listen. We are an innocence organization founded by two individuals, Lamont McIntyre and Daryl Burton, who are both exonerees of crimes they did not commit and collectively served 47 years in prison. One of them was compromised by the use of a jailhouse informant. Our organization works to free innocent people and provide support when they come home. And I'm here today to express my strong support for Senate Bill 116, also known as the Pete Coons Memorial Act, as our associates at MIP were referencing. This bill is a critical step toward ensuring fairness and transparency in our critical legal system. Jailhouse informant testimony is one of the leading causes of wrongful convictions, often incentivized by undisclosed deals and benefits. Senate Bill 116 would bring much needed accountability by requiring prosecutors to disclose their intent to use jailhouse witnesses and track their history of testimony and any benefits received. The tragic case of Pete Coons, who was wrongfully convicted based on false jailhouse informant testimony, reminds us of the devastating consequences when safeguards are lacking. Pete lost over a decade of his life, and while he was eventually exonerated, justice came too late. This bill will help prevent future injustices by ensuring full disclosure and transparency when jailhouse informants are used. I urge this committee to pass Senate Bill 116 to strengthen due process, protect the integrity of our justice system, and honor the legacy of Pete Coons. Thank you.
Thank you. Next, we will hear from Lamont McIntyre, private citizen by WebEx. Please introduce yourself and welcome to committee.
Good morning, Chair and members of the committee. My name is Lamont McIntyre, co-founder of Miracle of Innocence, and I'm here today as an exoneree who was wrongfully convicted for a crime I didn't commit. I want to voice my strong support for Senate Bill 116 and the Pete Coons Memorial Act. I spent years behind bars for a crime I didn't commit, like Pete did. Pete was convicted due to false testimony from jailhouse informants. Like many others who have been wrongfully convicted, Pete learned firsthand how unreliable and dangerous these testimonies can be when prosecutors fail to disclose their incentives and history. Jailhouse informants often testify in exchange for reduced sentences, drop charges, or other benefits, yet juries are rarely given the full picture. Senate Bill 116 would ensure transparency and accountability, requiring prosecutors to disclose when they plan to use a jailhouse witness and to track their past involvement in cases. This bill is a step forward towards preventing more wrongful convictions and restoring faith in our justice system. I urge you to pass this bill in honor of Pete and those who lost years and decades of their lives due to wrongful convictions. Thank you.
Thank you for your testimony. Appreciate it.
Absolutely.
Are there any other persons wishing to testify as proponent conferees on the bill? Not seeing any. Then committee want to draw your attention at your desk to proponent written testimony from Clayton Perkins, Chief Attorney, Capital Appellate Defender Office, BIDS Legislative Committee, Co-Chair, Kansas State Board of Indigence Defense Services. And with that, then, we will open it up for any questions. I do have a question for the proponents regarding some of the opponent testimony regarding that prosecutors are already required to comply with these mandates to disclose the content of jailhouse witness testimony. And if we could keep our answer kind of a little bit, we're a little bit time constricted, but yeah, please go ahead.
Yes, Madam Chair. My
Please
name is
reintroduce yourself.
Tricia Rojo Bushnell with the Midwest Innocence Project. So yes, the Brady versus Maryland is the U.S. Supreme Court case that does require that the prosecution turn over this information, and Giglio and these other lines of cases. The issue is it doesn't state out explicitly what those things are. It says that it must be evidence that is favorable to the defense. And what we have seen in practice is that defense attorneys and prosecutors will interpret what information is favorable to the offense differently. And so this puts everyone on a level playing field of letting them know what that information is they have to turn over, and it is the same language that 14 other states have adopted that provision specifically.
Thank you, and maybe you're the best proponent to ask this regarding the legislation in other states. I think you mentioned those. Do any of them have a requirement to document the requested benefits by an incarcerated witness?
They do, yes, because it's not so much whether or not they get the benefit, but that they've requested it or that there's an expectation that they may receive it, and that complies with the U.S. Supreme Court case law.
So if they ask for, if the request is not granted, that has to currently be documented?
That they asked for it, because the defense attorney can use it to cross-examine them, right? If you put them on the stand, you would say, well, you're only coming forward because you wanted this. And they can clarify and say whether they've gotten it or not, but that is information that could be used for impeachment that the U.S. Supreme Court has said the Constitution requires to be turned over.
So, but that would be even for what the testifying witness doesn't receive. Well, I made a request for additional time to do outdoor activities and I didn't get it in return for my testimony. So that would have to then be recorded under this bill?
So it's not any benefit that the witness ever requests ever. It's benefits that they request as they're coming forward and in exchange for this testimony.
No, I know, and then if they don't get it, all those have to be recorded even if they don't receive it in exchange for their testimony.
Even if they don't receive it in exchange, but only if they testify. So, you know, there's been this sort of assertion that there might be a floodgates issue, but unless there's a floodgates of jailhouse informants being used, it's really a small amount of information.
And how do we know then that the prosecutor's times wouldn't be used for recording all the requests from the incarcerated witness that aren't granted? And does that happen in other states?
So, you know, what we've seen again is typically when jailhouse informants do request something, they're either doing it in a conversation that they're having or they're doing it in a letter. So, you know, keeping those letters would keep that information and then writing down a note saying they also requested this, which I will tell you how these cases come to light years down the line is when we're able to look in the prosecutor's file and we see they already had a handwritten note saying they requested it. So folks are documenting it. They're just having to send it over when the witness testifies. So again, it's not any witness who's ever come forward. It's only a witness that is used or expected to be used at trial to testify. So it's a small subset.
Thank you. Senator Rose.
Thank you, Madam Chair. In looking at the list of opponents, it seems to me like in a situation like this that maybe the hope for this bill would be an amendment. Have you tried to work with the opponents to come to an agreement on an amendment that might make this agreeable to all sides?
So we have, and we have had several amendments offered over the years. You know, we did take out a provision on the jury instruction as a result of those conversations. But I will also tell you, quite frankly, that the ball has been moved a little bit. I feel like every time I'm here, I get a new issue that needs to be changed.
Thank you. Other questions? Not seeing any, then thank you very much for your testimony. And we will hear from opponent conferee Megan Assens, First Assistant Attorney General, Major Crimes, Office of the Attorney General. Apologize if I misstated your name, but you'll fix it when you introduce yourself, and welcome to committee.
Thank you, Madam Chair. Thank you, members of the committee. My name is Megan Assens. I'm the First Assistant Attorney General in charge of major crimes at the Attorney General's office. I want to say first off, as a prosecutor of 23 years now, nobody ever wants anything like what happened to Pete Coons or any other wrongfully convicted individual to happen. That is a tragedy for which everybody who is a prosecutor is devastated about. That kind of thing should not happen. And that being said, there is nothing in this bill that would prevent what happened to Pete Coons. Because what happened to Pete Coons was he ran afoul of an unethical prosecutor who was unwilling to follow his duty under the law. That prosecutor ignored the fact that the jailhouse informant recanted his testimony and refused to tell the defense about that. That is flat out unethical. It violates the discovery statute, which the proponents of this bill never mentioned, Kansas's discovery statute, which requires literally all of this. I would point respectfully the committee to my written testimony, which lays out all the duplications in the current state of the law that this bill has. I want to focus instead my testimony on what the definition of jailhouse informant is and how vague it is and how it would make this impossible for prosecutors to comply with across the state. Because the way this works in real practice is you get a note from the jail, from someone saying they've got information on X, Y, or Z, and that, even if you never use it, would trigger this. I will correct the previous speaker when she said it only counts if they testify. That is just respectfully not true. Look in the bill in the definition of jailhouse informants. It says basically if a prosecutor ever intended in the transom of time to possibly ever testify, then this attaches. And I want to remind the committee and the proponents of this bill that informants in the jail are people too. This puts their lives at risk. It's sundowns as exempt from CORA in 10 years, which means anybody can request the information and the names of people who have been informants. No one will want to come forward to provide valid information, and I have cases in my past and in my current caseload where people have come forward even not asking for anything. They don't want anything. They served their time, but they want to say, this guy told me that he killed this person and got away with it. So I want to tell you that. I want to bring that attention to law enforcement. Those people are never coming forward if we have something like this. A central registry kept by law enforcement. A lot of these people are very, very suspicious of the government in general, and a registry with a simple promise that it won't get hacked or that in 10 years the legislature will act to keep it exempt from CORA. That's not going to be good enough, and they're not going to come forward, and murders and victims' families will never get solved. And one last quick thing, I know we're very limited on time, so I will be brief. It is a devastating thought that a prosecutor somewhere in other part of Kansas who doesn't have the resources that we do, that we're lucky enough to have here and in other more populous areas of the county, maybe they don't see the note from the inmate. Maybe it slips under the desk or under a pile of papers, and maybe that same person decides they want to give evidence in another county in another case. And I, as a prosecutor, am held to what that person failed to do in another part of Kansas. And if my conviction gets flipped because of nothing I did wrong, who has to go in front of those family members of those victims? Who has to go talk to that rape victim that she has to relive every single traumatizing bit again? And all because somebody somewhere else, 100 or 200 miles away, didn't do what they were supposed to do under this law. And this law makes it so vague that it's going to be almost impossible for another prosecutor to figure out what they're supposed to do because it's very vaguely worded. I strongly urge this committee to reject this bill. Thank you.
All right, thank you. Appreciate it. Committee, next we will hear testimony from Sherry Shuck, Deputy District Attorney for Shawnee County, Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Good morning, Chairwoman Warren and members of the committee. My name is Sherry Shuck, and I'm a Deputy District Attorney with the Shawnee County District Attorney's Office. I'm also formerly a Pottawatomie County Attorney. And I am currently a member of the elected board of the Kansas County and District Attorneys Association. I also have over 20 years as a prosecutor in this county or in this state. And I agree with Megan. It is a tragic event what happened to Mr. Coons. And it is something that we as prosecutors across the state are dedicated to not letting happen because we do believe in the fairness of trials. And she is right. There is nothing in this bill that prevents that. This is not a legal gap. It doesn't cover anything. And we would love to sit down with the Innocence Project and find where that issue is and cover that legal gap. Because we have discovery statutes, and there should be accountability when prosecutors go outside the law and they go outside their duties and they go outside their mandates. You will hear a lot of testimony today, so I also won't just go back and forth over redundancy. But one of the things this bill does propose to create is a whole classification of testimony or a different set of witnesses. As a defendant, you sit in jail and you are protected by the Constitution and the laws of this state, and you are given those protections as you should be, and you have a mantle of a presumption of innocence. And yet if you are a witness who sits in that jailhouse, somehow you are less credible and you are not given that same protection. Now you're put on a registry that you don't get to exonerate, you don't get to expunge, instead you get exposed at a sundown. And all of a sudden, all of your criminal history, whether it has connected to this, whether you have reasons to recant, we have no way to really fully vet it, to investigate things, now becomes subject to things that we don't even know is going to happen. Something that a prosecutor's office may fail to do under bureaucracy will affect a prosecutor's office in 5 or 10 years. And we have to go back to a victim's family, just like Mr. Coons's family. That victim's family is just as important. And a prosecutor's office who did nothing wrong to a victim's family who did nothing wrong is now subject to bureaucracy, and not because of evidence that wasn't appropriate or credible or usable. We're going to have to do something different. There may be a loophole, and we may have to work together, and we should work together. But Senate Bill 116 is not that fix. Thank you.
Thank you. Next, we will hear from Thomas Stanton, Reno County District Attorney, Kansas County and District Attorneys Association. Please introduce yourself and welcome to committee.
Thank you. My name is Thomas R. Stanton. I am the Reno County District Attorney. Thank you, Madam Chair and committee, for allowing me to testify today. I don't talk quite as fast as you young ladies did. I will try to get my information in as soon as well as I can. I did submit written testimony. I want to address one issue, and that is that it was represented to this committee that there was a good faith effort by the other side to negotiate in this case, try to come up with a bill that all sides could agree with. I've been informed, I wasn't part of those negotiations, but I was informed that there was no good faith negotiations. We're happy to try to get something done. The problem is that Section A is completely irrelevant and unneeded. Everything that is in Section A is already something that we're required to do. I've been a prosecutor for 34 years. I have had these types of cases. I'm going to go off a beaten path just a little bit in my testimony and give you two examples. When you're talking to victims, and you need to worry about the victims in the community, because we had a case in which, in 2003, which is mentioned in my testimony, in which a woman was found dead at the bottom of the stairs of her apartment. There was a witness that came forward in that. No deals were given. You know what he got? He got beat up twice. He came into court with a black eye. The second one was an innocent woman in 2011 who was killed in her kitchen in front of her 5-year-old son who went for help. One of the pieces of evidence in that case was that the person who executed her told people in the jail what happened and actually acted it out. And we had video. Their testimony was nothing but to support the video, and in both of those cases, the defendant was convicted because they committed the crime. Please do not chill the speech and the possibility of witnesses coming forward by passing this bill, because it will harm the victims of the state of Kansas. Thank you.
Thank you. Next, we will hear from Mark Bennett, Sedgwick County District Attorney, via WebEx. Please introduce yourself and welcome to committee. Okay, we had an update from Mr. Wagaman with the Kansas County and District Attorneys Association updating us that Mr. Bennett has been pulled away to other business and his testimony will be submitted as written only testimony. Thank you. Next, we will hear from Steve Howe, Johnson County District Attorney, Kansas County District Attorneys Association via WebEx. Please introduce yourself and welcome to committee. And we are still waiting for Mr. Howe to log in on WebEx, so we will circle back if he's available a little bit later. Next, we will hear from Susan Hiller Reichmeyer, Kansas County and District Attorneys Association Board Member and Finney County Attorney. Please introduce yourself and welcome to committee.
Thank you, Chairman and committee members, for allowing me to testify in opposition of this bill. I'm Susan Richmeyer from Finney County. I kind of have a little bit different perspective being from a rural area. I also think that I reiterate everything everyone has said before. It's been a tragedy for the Coons family. We don't want those things to happen as prosecutors. We do our best. Policy in my office and many of those that I talk to is everything goes. So anything we have in our office upon a discovery request will be given to our defense counsel and to the defendant in the event they're representing themselves pro se. So that shouldn't be an issue, what we're talking about today and what we're talking about today wouldn't have fixed the problem for peat coons. But being from a rural community and knowing my counterparts in smaller communities than mine, I do know that we have and they struggle with their case management systems, and they're not doing things electronically. So being part of a database, being part of something that would continue year after year after year at this time is fiscally not an option for these really small counties. They don't have electronic case management systems, many of them who do have them.
1 minute remaining.
Don't have staff to handle that, and they don't have the economic means to create that for them. It's been a struggle for us every year. And so again, I would just iterate again that we strongly oppose this bill. I have also provided written testimony for all of your review, and I hope this lends a little bit different perspective. Thank you.
Thank you. Do we have either Mark Bennett or Steve Howe on WebEx to testify? Not at this time. Committee, you have written opponent testimony at your desk from Ed Klump, Legislative Liaison, Kansas Sheriff's Association, Kansas Association Chiefs of Police, and Kansas Peace Officers Association. Is there anyone else wishing to testify as opponent on the bill? Not seeing any, then we'll open it up for any questions. Not seeing any. Is there anyone who wishes to testify as neutral on the bill? Not seeing any. We'll ask one last time if we have Mr. Howe or Mr. Bennett on WebEx. Not hearing that they're present, so we will consider their testimony as written only then. And with that, we will close the hearing on Senate Bill 116. And with that, then, I think we have concluded our work on time, everyone. So thank you for that. And tomorrow is our last day to work bills and get them out of committee and hear them as well. So please have any amendments ready. And thank you, everyone, for your testimony, for your work, and for following along online or in the committee meeting room. With that, then, the meeting is adjourned.